good to get use out of it. We will go on the record in the matter 25 CM 187, State of Wisconsin versus Joshua Plan. The state appears through Assistant District Attorney Jose Villa in person. We have Mr. Plan in person without counsel. Off the record, the court inquired if Mr. Plan was going to apply for a public defender. He said he is not. He is going to represent himself at this time. I'm not necessarily seeing there is a set victim or a victim alleged in this case. Before I begin, is there an offer that can be presented?
Doesn't appear to be at this time. This is a DA Schmidt case, Your Honor.
It's a DA Schmidt case. All right. Did you receive a copy of that criminal complaint?
I did.
And can you read, write, and do you understand the English language?
Yes,
And did you read that thoroughly?
I did.
And with regards to the 2 counts that are alleged and the facts alleged in there, do you understand them?
Yes.
Do you need me to read them to you out loud?
No.
Okay. Not guilty pleas will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial once you request one, or if you request one. If you're going to be representing yourself, the best thing for you to do is to contact not this guy in the DA's office, but the actual district attorney, because it's going to be his case. And you want to, it looks like you have information. I don't know if that's evidence or things to support your side. But those are things you're going to want to show and talk to the district attorney about. And he will discuss with you if there's any potential way to resolve it outside of court or with some resolution with certain things that he may ask you to do or not do, but your discussion with the DA. So what I'm going to do is I am going to set this matter for a status conference a little bit down the road. You're local, so it'd be easy for you to come back in a shorter amount of time. But if you'd like, I can schedule you to come back for next week sometime. It is the DA's week. I could extend it longer, but then I need you to promise me you're going to contact the DA's office and talk about the case and see if it can resolve. Because if I set it longer, it just means it's going to take longer to go down the process to find out what's happening, or do we need to set it for a trial or what? Okay.
So you're saying I may be able to just settle out by talking to the DA over the phone?
Depends on how he sees the case and what you're presenting to the case. He may have an offer to you. He may say, if you engage in X, Y, and Z, I'll do this, or this is what I feel comfortable doing.
Okay.
So have a conversation with him. I can, again, either set you to come back next week and come in front of the court and let me know what the discussion was about and if the matter can resolve, or I can schedule it a little further out. What would you prefer?
Probably a little further out. I got quite a few jobs going right now with
What do
coming
you-
into winter here. So
What do you do?
construction, concrete, framing, siding,
Now,
general
is there
contractor.
a day that, because sometimes there's a little bit lesser of a day.
Not really that I
Doesn't really
could.
matter, just goes with
Yeah.
the job.
So I guess if I could talk to him and then I guess, yeah, it's up to you, I guess.
And I don't know, generally, some contractors, construction, they work a little more local, some work out of town. I don't know, but at the next hearing, I'm totally okay if you want to call in. So you're not taking too much time out of your day and you're not having to take a full day off of work.
Okay.
So what I can do is I will schedule you for 1:45 on November 18, 1:45 November 18. You'll get a notice.
Okay.
And so it'll have a call-in number on there, or you can appear by Zoom like this if you want. You don't have to. Call-in is totally fine. And at that hearing, I'll be informed what it is you talked about and where this case may be going.
Okay.
All right, so come get your notice and then you are free to leave.
All right.
All right, Mr. Burke, I'm gonna send you into a confidential breakout session, okay? You're just gonna have to hit a button. This is Miss Sherwood. There you go, the room is open.
Zoom instructions are free.
Mr. Villa, is he going to need to sign a form saying that he's not represented?
No, if you want.
Yes, Your Honor.
It's on this floor. You go all the way down, it's the only office on the right. You can schedule a time to.
Okay, and that's where you're going. Good, because you have to sign a form saying that you do not have an attorney right now. That's the only way the DA can talk to you. So go down there and say, I need to set up an appointment with the DA. I need to sign the form so you can talk to me.
Okay,
Okay?
all right.
Thank you.
Yep.
Are you here for somebody or with somebody? And who are you? Oh, you are Ms. Shabash. Okay, you can come on up. We will go on the record in the matter 25 CF 145, State of Wisconsin versus Jacqueline Shabash. The state appears through Assistant District Attorney Jose Villa in person. Ms. Shabash appears in person without counsel. We're set for an initial appearance. Ms. Shabash, were you going to apply for a public defender?
Yeah, I was talking to him out there. I do qualify.
Okay, you qualify. And so they would be trying to get an attorney for you. There's two ways I can go about it right now. We can go through the initial appearance and I can set that next hearing, which is the preliminary hearing. And I could set it either closer in time, and that's within time limits, within 20 days, or I can give you more time so that they can find an attorney for you and push it beyond 20 days.
Probably more time.
Okay. And so did you receive a copy of that criminal complaint?
Yes,
And can you read, write? You understand the
Yes.
English language? Do you need me to read those to you, or do you fully
I
understand
fully
them?
understand.
And are you still on Bearhart Drive?
Yes.
Telephone ends in 8394.
No, I got a different phone number.
May I get it, please?
Yes. I have to turn my phone on. Give me a
That's
minute.
Sir, can you please remove your hat? Thank you. Ms. Herman, can you please shut off your phone? Was that your phone? Oh,
Oh,
was
that's-
that
that's my
just turning
phone.
on?
Yeah, I'm
Okay,
turning it on.
sorry, you moved like it was your phone.
I was just moving at the same time. Sorry, my phone is really slow.
That's okay. Okay, you're not kidding. It's very slow.
It is very, very slow. Okay, 715-954-5193.
May we send you text message notifications?
Yes,
Not guilty plea will be entered on your behalf as it relates to count 2. We're going to set a preliminary hearing waiving time limits because you'd like more time, correct?
yes.
Waiving time limits for the other matter to allow the public defender's office to be able to locate an attorney for you. Your week or a Schmidt?
This is my week, Your Honor.
I can schedule you for December 8th at 3, December 8th at 3.
Okay,
Okay?
Yes.
So you can come up here and get your notice and then you are free to leave and we will see you then. And hopefully the PD's office will have found an attorney. All right, thank you. First, Ms. Herman, did you get that application complete? All right, come on up. And bring it right to me. Thank you. We will go on the record in the matter 25 CF 139, State of Wisconsin versus Eva Herman. The state appears through Assistant District Attorney Jose Plea in person. We have Ms. Herman appearing in person without counsel. We were set today in this matter for an initial appearance. Ms. Herman does not qualify for a public defender. She has now filled out the petition for appointment of a court-appointed attorney. You're a seasonal worker and it looks like you work at Dead End Hayride.
Yep.
That sounds pretty cool.
It is.
Too scary for me, but
It's
super
fun.
fun. If you're not going to get paid until the end of the season, how don't you qualify? I'm not seeing you own any real property.
Because I own my house.
Okay, because it doesn't say that on here.
Oh, where do you,
So-
I don't know where you put that at.
On the second page, do you have any mortgage or do you own it outright?
I own it outright.
And then, okay, so I'm gonna write in here, own house. And how much is your house worth?
They looked it up as 250,000.
Okay, 250,000 in equity. All right, okay. Now I'm looking at your case. Two charges, not significant or serious charges. Before we begin and we go down the whole process, is there an offer that can be presented to Ms. Herman?
Yes, Your Honor. The offer would be to amend the felony possession down to simple THC misdemeanor for court costs and dismiss and read in the drug paraphernalia.
All right, so you have a decision you can make. You can retain an attorney and you would need to put money down and the court would require at least $350 down for an attorney. And then this matter can go down the course of the felony and have the preliminary hearing and then go all the way down. The process is a normal case would go. An offer has been presented right now when you don't have an attorney for you to consider to amend that felony possession of THC down to a misdemeanor simple possession for costs only and to dismiss and read in the other matter. You have $250 posted today, so theoretically, if you want to argue, that could cover the costs.
That'd be perfect.
Would you like to accept that here today?
Yes, I would.
Do you need any more time to look for an attorney or to get a court-appointed attorney or to retain your own private attorney?
No,
Do you need an attorney to be able to consult and to see if this is a good offer and deal?
no, Your Honor.
Do you understand an attorney goes to law school, they learn about the law, they learn how to negotiate and to look for facts and defenses in a case? You understand that?
Yes, I do.
So there are certain advantages to having an attorney, and you understand that?
Yes, I do.
And there are certain disadvantages to not having an attorney, such as the fact that you may be able to look at the facts of this case, or an attorney may be able to and may say, you know what, you actually have a defense here and we could get the whole matter dismissed. Do you understand that could be a probability?
Yes, I do.
And knowing that things like that could be overlooked without having an attorney, you wish to accept the state's offer
Yes, I do.
and represent yourself.
Yes,
How old are you?
I am 47.
Can you read, write? Do you understand the English language?
Yes, I do.
Any drugs, alcohol, or other medications?
Nope.
Formal motion to amend,
So moved.
granted. Do you understand you would have the right to a trial? You'd have the right to have your attorney or yourself cross-examine the state's witnesses or call witnesses to testify for you. You would have the right to testify on your own behalf or remain silent and not have your silence used against you. You would also have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. You would also have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights you're giving up?
Yes, I do.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, I do.
Do you understand that the state would have to prove on or around September 23rd, 2025, you possessed a substance? The substance was a controlled substance, THC, and that you knew or believed that substance was a controlled substance, THC. Do you understand what the state would have to prove?
Yes, I do.
Do you understand the maximum possible penalty could be a fine of up to $1,000 or 6 months of incarceration or both?
Yes, I do.
Do you understand the recommendation is for costs only? But do you understand I'm not bound to follow that?
Yes, I do.
Said differently, I could sentence you to the maximum possible penalty if I thought it was warranted. You understand that?
Yes, I do.
Do you still wish to proceed and enter a guilty plea?
Yes, I do.
Are you admitting here today you in fact did possess an illegal substance, THC,
Yes,
and you knew it was THC?
yes, I did.
Do you have any questions for the court or for Mr. Vila, the state, before we proceed?
No, I don't.
As to amended count 1, possession of THC, simple as a misdemeanor, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of simple possession, THC. Count 2 will be dismissed and
This is where the legal process becomes especially important. Eva has already admitted to possessing THC and entered a guilty plea after the charge was amended from a felony to a misdemeanor. Before accepting that plea, Judge Melissa R. Mogen carefully confirmed that Eva understood every constitutional right she was giving up, including her right to a jury trial, to remain silent, and to require the state to prove its case beyond a reasonable doubt. Those safeguards exist to ensure every guilty plea is made knowingly and voluntarily. In return, the state recommends a significantly reduced resolution based on Eva's decision to immediately accept responsibility. Do you think accepting an early plea agreement was the right choice, or would you have wanted to speak with an attorney first? Let's return to the courtroom as Judge Mogen delivers the final sentence.
the required DNA surcharge and just $50 in court costs and fees. I'm waiving the rest because again, you're taking care of it and being responsible today.
Thank you.
So you have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need to order your DNA. The jail probably has it. I'm not quite certain, but you have to go to the sheriff's department and see if they have your DNA. If they don't, they'll just quick swab you. You have the right to request it be expunged from the CODIS system through a written letter to the Department of Justice. It's easy. You can Google it. So
Okay.
it's pretty easy to do if that's what you want to do. Come and get your document, bring that to the sheriff's department, and you're good to go.
Awesome. Thank you. very
Thank
much,
you.
Honor.
We will go on the record in the matter 25 CF 143, State of Wisconsin versus Catherine Anderson. The state appears through Assistant District Attorney Jose Vila in person. We have Joel Feliski, Defense Counsel, in person. Ms. Anderson also appears in person. We're set today in this matter for an initial appearance. Joel Feliski makes a special appearance on her behalf today. Mr. Feliski, were you able to go over the criminal complaint with Ms. Anderson?
I was, Your Honor. I believe she understands the charges here and the maximum penalties. I was also able to e-form her, and she does qualify for the public defender services. At this time, we'll waive formal reading. I see that there are not any misdemeanors charged here, so we will be waiving time limits for setting the prelim.
All right, are you still on Larson Road?
No,
May I get an updated address?
Borg
please?
Road, 24554. Borg, B-O-R-G Road, Grantsburg.
All right. And all right, telephone number,
715-557-3604.
36 what?
04.
04. May we send you text message notifications of upcoming hearing dates?
Yes,
All right, and you went over both of those counts and waiving time limits. Your case?
Yes, Your Honor.
I can do December 8th at 3:15.
That will work for my calendar, Your Honor.
All right, December 8th at 3:15. You can come up here and get your notice and then you are free to leave.
Yeah, they'll get you a copy. Yeah. Just be in touch.
All right, I'm not sure if Ms. Sherwood is coming back.
Your Honor, I believe she did have an opportunity to give the criminal complaint here with this gentleman. Is that correct, sir? Did you get a copy of the criminal complaint in this case?
We will go on the record in the matter 25 CF 141, State of Wisconsin versus David Jerome. The state appears through Assistant District Attorney Jose Vila in person. Mr. Jerome appears in person without counsel. He does not qualify for a public defender. He is going to ask for a court-appointed attorney. Before we begin, Mr. Jerome, did you receive a copy of the criminal complaint?
Just today,
And can you read, write, and do you understand the English language?
yes.
Do you need me to read those counts and charges to you and the maximum penalties, or do you understand them?
I understand.
Do you need me to read anything to you on that complaint?
No,
Are you still at 6th Avenue North?
correct,
Telephone ends in 7749.
correct.
May we send you text message, or no, 656 is a landline, isn't
It's
it?
still my cell phone.
Oh, it is a cell phone? May we send you text messages?
Yes,
Okay, not guilty pleas will be entered on your behalf as it relates to counts 2 and 3, the misdemeanors. As to the felony, you can have the preliminary hearing within 20 days, or you can extend it beyond 20 days, whatever you feel more comfortable with.
okay.
So you want to go beyond 20 days?
Yeah, let's extend.
Okay, so we'll do that. And a court appointed, and let's just see. Based upon your application that you have here today, you would need to put down $300 as like the retaining deposit type of thing to the county for an attorney to be appointed. Do you know when you'd be able to have the money to put that down?
Second Wednesday of the month.
Second Wednesday of the month. And we've already passed that here. So you're telling the court you believe that by November 12th, you'd be able to pay?
Yes,
All right. So I'm going to say $300 by November 14th. Okay. So that's the Friday after the second Wednesday.
and I have to bring it here.
Bring it here. So
Okay.
it's $300 and then it will be $50 a month thereafter. So starting after you pay that $300 in November, it'll be $50 in December every month until your case is resolved. Okay?
Yeah,
And then let's look at attorneys.
Judge Melissa R. Mogen concludes this case by accepting Eva Herman's guilty plea to the amended misdemeanor possession of THC charge. Rather than imposing jail time, the judge follows a lenient resolution focused on accountability, limiting the financial penalty to the amount already posted and acknowledging Eva's willingness to accept responsibility at the earliest stage of the case. The hearing demonstrates how early cooperation, a negotiated plea agreement, and acceptance of responsibility can influence the outcome of lower-level criminal cases. At the same time, Judge Mogen carefully ensured that every constitutional right was explained before accepting the plea, reinforcing the importance of fairness throughout the process. If you found this case as intense as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more powerful courtroom breakdowns.
Read in for purposes of sentencing, a judgment of conviction will be entered today. Argument, Mr. Vila.
Your Honor, this is a low-level offense, and Ms. Herman is here today accepting responsibility for her decision to possess that substance, as which I believe court cost is an appropriate situation to resolve this matter. Thank you.
All right. Ms. Herman, would you like to make any argument or statement to the court?
No, I would not.
Okay, this is a low-end offense. It's a possession of THC. And having been caught in possession of THC, a second or subsequent offense means it's charged as a felony. Again, very low level. You're accepting the responsibility. You're pleading guilty today on the initial appearance. I think costs are appropriate. So I'm going to limit it to what you have posted, $250 cash. Okay, that covers the required